Good morning, everybody. Welcome to the Courtroom Files Live. Getting started a little bit early this morning with Judge Fleischer. He is already off and running, so let's see what's going on with him today.
License and liability insurance. You're not allowed to drive. You need to have car insurance. Do you understand?
Yes, sir.
If I find that you drive without it, I likewise, I'm going to revoke your bond, put you in jail. No more PR bonds for you. Tell me, ma'am, do you have the ability to hire a lawyer?
No.
Okay. I will have you fill out an application. We'll look to see whether you qualify. For now, I'm going to have you, shit. For now, I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you eventually meet with Fleischer for your bond conditions, and then we'll have you take your signature box, ma'am.
Yes, sir.
Right this way. Go ahead and sign for your reset, please. All right, Judge, next is page 17, Alvera. Oh, I don't see any, but there's, oh, Mr. Lowell just signed on. Okay, we can wait for him.
Well, let's wait a little bit. You know, he has to come rather late, so we'll wait for some time.
Okay. Next, Judge, is page 19, Perez. Come on up.
Stand right here. Everybody talk.
You're Freddie Perez.
Yes, sir.
Mr. Perez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On March 10th, 2025, officers initiated a traffic stop at 4841 block of Mount Houston Road in Harris County, Texas. Numerous vehicles were observed inside of a parking lot in a pit. The officer observed the defendant driving a white Honda, engaging in reckless driving by doing approximately 4 donuts. The defendant's vehicle was coming close to hitting people standing by the pit and other vehicles as well, disregarding the safety of the other people and their property. The defendant was the only occupant of the vehicle.
She's the only occupant.
Yes.
Okay, can you run his license, please?
Yes, Your Honor.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in a reckless manner again, not to do donuts, street takeovers, racing, any of this nature. If you do, first, I'm going to put you in jail. Next, I will take your ability to drive away from you. Do you understand?
Yes, sir.
It's valid, Your Honor.
All right, you're not allowed to drive unless you also have valid liability insurance in your name. That is a condition of your bond as well. So if you don't have car insurance, you're not allowed to drive. Do you have a lawyer today?
No, sir.
Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify. Do not leave until you sign our bond conditions. Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take your signature box. So-
Can I just say something? I want.
No, don't. We'll talk later, please. Thank you.
Right this way. Go ahead and sign for your reset, please. All right, Judge, I'm waiting on Luis to swing by for Spanish arraignment,
Okay.
and that's it for me.
So do you mind filing that? No driving without
Yes, Your Honor.
car insurance, and then no reckless driving, all that jazz?
Oh, we did have a THA. You ready for that one?
No, just give me an application. We'll see when.
Okay.
Or who is it?
Johnson, Kamisha, come on up. Yeah.
Yeah, that's what I could think of.
Violation on Jones again, Kayla Jones, Dustin's gun.
Did you look over, Judge? Booker?
Okay, well,
Can you, try to pinpoint Felicia where he is somehow?
At the
Find,
time?
Yeah.
Yes. I'll reach out to them in just a moment.
no, don't reach out to him.
No, then, like,
Oh, okay,
the
yeah.
case manager.
Yeah, so we're just waiting on. Yeah, no, I can appreciate it. Thanks, me long. Right, exactly. Thanks.
Hi, Marcos.
Hey, are you Judge? Coach?
Uh, okay, yeah,
I got two, Judge. Gonzalez is the first one. We had spoken about both of these guys about 2 weeks ago. It's a PC, right? They both, well, he's done the TRAS. We've emailed the application, the mitigation. We're waiting on Ashton, guys, for a decision.
Sorry, which Gonzalez?
Diego.
Diego. Got three today.
Sure. Only three? And if you remember, Judge, when we were here last time, we've already done the TRAS, already done the app, and then for some reason, I don't know if there's a change across the board or what, but all of a sudden we needed to do mitigation. So,
right.
and you were like,
You turned it in when though? I mean,
26, March
Right.
6th.
And it looks like we do have it, it's pending approval. I can send an
Right.
email to her and see if we can get an answer.
Sure,
really
okay.
Soon.
Yeah, let's do that. It's on Gonzalez. Who's the other one?
Guevara, Guevara. This one, Judge, we didn't, as of last time we were here, we didn't have the letters, but we have them now and we're submitting them today. Because this is the one,
150.
Judge, we did the TRAS, did the application, then all of a sudden they changed it on us and said, you have to get us everything. So that,
All right, so you have everything to turn in today?
yes.
All right, so let's set it a week.
Okay. Do you want to do a week on each one?
No. Let's see, because everything's turned in on Gonzalez. Let's see if she has a response on that, and then on Guevara, we'll set it off a week.
Okay. Can I waive Guevara's appearance, Judge? Because he keeps missing work every time. They're both here.
Yeah.
Okay, thank you. And I'll wait on the other one.
Yes.
Okay, perfect. Sounds good. Move on up.
He'll sign on Simpson.
Okay, Judge Fleischer starting early implied to me that he had a lot to do. Maybe he's just trying to get out early today. But since it's a little quiet over there, I'm going to go over to Judge Elmore. This is out of Wexford County in Michigan, where a little while ago he did a sentencing. So let's check that out.
On behalf of the people, Robert Hertzel for Mr. Sapp, who joins me at the table, Your Honor.
Thank you. The court also recognizes before it this morning Ms. Lindsay Simmons, an agent from the Michigan Department of Corrections. We are here today for a sentencing in this case. There are two counts. One is a count for possession of a narcotic less than 25 grams, and then the second is for a tampering with evidence. Let me take a quick look, see if I have any need for correction. As I'm flipping through the pages here, I'll also make a note that the court received last week a defendant sentencing memorandum that made it to my desk on Friday. I had a very busy day on the docket in Lake City, so I read it this morning. We could please, everyone turn to page CFJ 284, page 13. Going to look at entries, multiple, 19, 20, 21, 22, 23. Those offenses appear to have occurred while the defendant was on bond for entry 18 of 29. Yes. All right. All right, those were the only things that I seem to have caught. Let's turn it over to the government, Mr. Hertel. I'm sorry, Mr. Carnes.
Thank you, Your Honor. I have received and reviewed the PSI. I did not note any corrections or additions.
No.
Yes, Your Honor. After reviewing with my client, we also do not have any revisions or corrections.
Thank you. Elocution, sir.
Yes, Your Honor. As noted, I have been discussing this with my clients, and in addition to what we put in our report, I know he does want to make some statements to the court. I don't want to take away from his thunder too much because they are very authentic statements that he does want to make to the court. But what I will say in summary, without oversimplifying and taking away from it, he realizes that certain things are triggers. That's not an excuse, but it is an explanation. He has been in treatment in the past, and he has learned some of the skills, so he's able to recognize where he messed up. But he knows in his heart that if he had completed more of sober living in the proper environment, the proper support structure, he almost certainly would not have responded to those triggers in the same way. He wants to make sure that he doesn't make those same mistakes in the future, so he wants the opportunity to be able to do so as far as going to sober living. We do believe the recommendation from the probation department is appropriate. We ask the court to factor that in. We know that technically he doesn't have any time served, but we ask the court to fashion a sentence appropriate, knowing that he was lodged this entire time. And again, he does have some statements that he would like to make to the court. Thank you.
All right, thank you. Mr. Carnes, on behalf of the people, sir.
Thank you, Your Honor. One thing I noticed in the narrative, and I noticed this earlier, reviewing the police report, is the defendant was alerted to law enforcement because there was a be on the lookout for erratic driving. And that's troubling. There weren't any roadside sobriety tests on, so there's nothing to charge him with that. Insufficient evidence, I think, is how we felt. But it does show that this was an instance where the public safety was put at risk. And I think that's worth considering, as well as the defense history on probation and parole. He was on parole in this case. In light of all those, I do think a prison sentence is appropriate here, despite the recommendation. I'll leave the length to the court's discretion. Thank you.
Thank you. Mr. Sapp?
Yes, Your Honor. I just wanted to say thank you for giving me this opportunity to talk. I know that I've messed up a lot in the past and words have to hold weight. Nobody probably believes the word that I say, but I messed up. I made a mistake. I've been to treatment one time in my life. I went to DeCoste. I benefited. I figured everything out. I thought I had it together. I didn't go to sober living like I should have and attend meetings. If I would have did that, I would have had positive sober peers around me when I had the 2 deaths happen that were days apart. My grandfather died, my kid's mother died, which is no excuse. I should have had a different way to cope with it that was healthy. And I didn't. I had people around me that were getting high. I shouldn't have came back to Cadillac. If I could go back in time, I would go to sober living and I wouldn't come back to Cadillac. And I know you got to change your people, places and things, and I'm ready to do something different. I feel as prison hasn't helped me. I feel like jail the monotonous is kind of making me think more on what. And I just feel that if I have the last chance to go to sober living, Your Honor, I think I could do it. I have faith in myself. I want help.
How did you go to the program last time? The one back in November?
I went, Lindsay.
All right,
Your Honor.
okay. And
I loved it.
all right. I'm sorry, I didn't mean to interrupt. I just wanted to ask you that question since you were talking about it. Anything else?
I just wanted to say that I'm sorry to the court. I'm sorry to my mother. I'm sorry to my kids. I'm sorry to myself. I'm disgusted and disappointed in myself because I know I can do better. I know that don't, I'm sorry, if words have no meaning, I want to say I have weight behind them. And the only way that I can really prove that I'm sorry is change behavior. And I know that. And it hurts when nobody believes you because it's like the little boy that cried wolf because I actually really want to be clean and be better.
I don't doubt that you want to be clean. You mentioned somewhere there in the beginning that you don't think anybody believes what you're saying. I don't agree with that, at least for me. It's not that I don't agree or think that what you're telling me is true. I don't think anybody chooses and wants to be addicted to a controlled substance to this level. I know and see that you can be that you're disgusted with yourself. I don't have any reason to think that. So again, I know that you want to be better, and I know you want to get over this. You know, you're 32 years of age, so you're no longer the youngest kid or youngest person here in the courtroom. You're an adult, 32, and you've been struggling now with controlled substances since you were very young. It's a very broad amount of substances: alcohol, marijuana, methadone, methamphetamine, cocaine, benzodiazepines, and opiates for a long time. in this situation, you had just gotten out of a rehab program back in November, and it took less than 6 weeks before you picked up another set of charges. And you picked those up during a time period when if you had been into the sober living facility that they were willing to send you to and pay for and do everything for you, you chose not to. Mr. Hartel mentioned on page 1 of his memorandum that he provided that your failing to go to sober living unit was, quote, a mistake. Now, I don't agree that it was a mistake. It was definitely, though, a bad choice, because instead of doing that, and I know here it talks about, and Mr. Hartel said it was in part to help be with your girlfriend, take care of children. Well, I don't buy that. Yeah, I understand that your grandfather passed away, and I'm very sorry for that. And the mother of the 2 children passed away, and I'm very sorry for that. Moving in to help support your girlfriend, I don't know. You clearly weren't doing that in this particular instance. Now, this is not such a simple case as to say, here's the defendant who was caught with some marijuana. Instead, as Mr. Hartel talked about, this began with a BOLO, or a be on the lookout call, for an erratic driver in Slagle Township, which we know is way west on the western side of Wexford County. And if I remember correctly, this is the incident where covered multiple different townships. 1 second as I review here. Took a long, in this instance, you took a long time to stop the vehicle. You pulled over the roadway, making furtive movements and gestures to the back seat, and observed that you had a blue latex glove in your mouth, and an apple juice container. You were basically you were swallowing the controlled substance. You had over $1,100 in cash in your pocket. And when I look at somebody who's got $1,100 of cash in his pocket, first thing I want to do is go here in the back and look at his employment history. Yeah, there's nothing underneath your employment history. And at this time, you were living in town on Wheeler Street. So, did he have a driver's license? Should have probably had a driver's license. In the car.
He had a permit, I believe, Your Honor.
Okay.
Yeah.
And whose car was it? You know? So you've got no job. You're out in the west part of the county, 30 miles away from where you live, with $1,100 of cash in your pocket and controlled substance. Here, was it cocaine? Is that what it was?
Yes, sir.
Yeah, cocaine, and you're trying to swallow it. You could have been in sober living, but you chose not to, so you could, quote unquote, take care of your girlfriend, end quote. I don't believe it. I think you were up to no good. And we know the cocaine is making a comeback, and into the area. Oh, that's right here. This is what I remember. Subject then stated he stopped at the Corner Express gas station and that he was eventually heading to Elk Rapids to see his girlfriend. So he wasn't taking care of her if she lives in Elk Rapids. There goes that argument. Subject immediately changed his answer, stating he was driving home to Cadillac. So she's in Elk Rapids, way north. He then goes to Mesick, then comes down to Slagle, and then is coming into Cadillac for a guy who's got no job and driving a car and with $1,100 of cash in his pocket and a rubber glove and stuff with cocaine. Yeah, no, I don't buy it. And granted, you were trying to swallow the cocaine and stuff when you got caught. But I also noted here, he had marijuana in his system and there was a roach in the car. And he had amphetamines, which is, what looks like it says the prescription. And he had benzodiazepines, also a prescription in his blood while operating a motor vehicle. Yes, sir.
If I may, Your Honor, I believe the factual basis that my client gave at the plea was that he swallowed a roach. Not that that's a huge difference, but just so the court is aware. And that was why Mr. Carnes made it part of the sentencing agreement not to charge the.
Okay, but he's still driving with methamphetamine and benzodiazepines, controlled substances in his system for which there's a zero tolerance, right?
Not denying that, Your Honor.
Yeah. So, and in the glove, I'm sorry, the glove also contained Adderall, Klonopin. No. This is not simply an incident where you fell off the wagon and you're around bad people. While I can't sentence you for it, and I don't, I think you were dealing or delivering. Otherwise, where'd you get the $1,100?
My mother's there.
Why did she give you $1,100 in her car to drive around a couple different counties?
A few hundred was mine, but I did work for my brother full staff services when he was working, but it's supposed to get the wheel bearings fixed. And I came back from sober living. It was to help my grandfather because my mom had to work. It wasn't my girlfriend, sir.
All right. Well, anyways, that's all right. So you're clearly up no good. You got a load of drugs in your system and you're driving a car. That causes people to call out for an erratic driver. You were somewhere between Elk Rapids, Mesick, Slagle Township, coming back into Cadillac. I don't buy it. Then when I look at your history here, it is for a 32-year-old young man, terrible. You began with juvenile issues, but one of them was Nolly Pross, the other one was only a curfew issue. But then in 2009, your adult criminal history begins with receiving and concealing, and you had probation violations. So already I'm starting to think supervision is not going to be too good. You had at least two different sets of probation violations. In fact, one of them resulted in a charge, but that charge was dismissed. A second one was charged, but then a third one, you get a driver's license suspended, which means you'll ignore the rules as long as you think no one's going to catch you. Now, between 4 and 5 of 29, you made an impressive 7 days. Then you get to 6 of 29, and that one you made it about 10 months. Again, 6 of 29 gets a driver's license suspended, but to me, that always tells the court this is a defendant that's going to do what he wants as long as he thinks he doesn't get caught. But then between 6 and 7 of 29, you made it 2 months, not even 2 months, a week shy of 2 months. Now you're picking up some serious charges, including breaking and entering of vehicles and damage to vehicles and so forth. Now, in that case, you got probation, and this is back in 2012, and you violated probation multiple times, including one was a retail fraud. So that gets me down to number 8 of 29. That case was dismissed. I'll skip that one. Number 9 of 12 or 29 was dismissed. I think it's all part of some package deal because then you actually had, wow, wait, hold on. You had 1, 2, 3, 4, 5, 6 different dismissals in a row. Anyways, in the middle here at 12/29, retail fraud committed while on probation. 15 of 29, shortly after being released from probation, you have some probation violations. 16 of 29 committed while on bond. You made it a couple years before picking up 17 of 29. You got another one, 18 of 29, another retail fraud. Larceny seems to be a big issue here because 19 of 29, there's another larceny case. That one occurred while on bond. 20 of 29 occurred while on bond. Again, that one's not a very big case. That has something to do with the dog, but 21 of 29 occurred while on bond. Right now, we're only 6 years ago, back in 2019. Another one in 2019, because these stack up real quickly. We're all within a couple months. 22 of 29 occurred while on bond. 23 of 29, still in 2019, occurred while on bond. Just let me take a quick look here. 2019 was a very busy year for you. 2019, you picked up 1, 2, 3, 4, 5, 6, 7 different cases while on bond. And you also had probation violations for the last one from 2019, entry 23 of 29. Now, you were released early back in 2021 for that 23 of 29 case. You were released early for placement in the Sunrise Center, but you failed to show up for treatment. So while it may have been, the most recent one may have been your only rehab program, which of course you were off of the sober living, which you rejected. So you can come home and run around the county with drugs in your system and other drugs and a lot of cash in your pocket. But back in 2019, they gave you another opportunity and you just said, nah, I'm not going to do it. I'm going to disappear. So a bench warrant had to be issued for you. And that was, of course, in this court. Well, that was followed up, by the way. You had been placed on, you were on probation. From the way I look at this one, 23 of 29, your disposition sentence was on February 10th. Your next case, February 10th, same day. Back to more crimes of larceny. You had bond violations in that case, 25 of 29. That one, oh, that you picked 2 cases on the same day. Wow. That one occurred while you had additional bond violations. 26 of 29 occurred while on probation for larceny type cases here. And then this one, you're still on active parole for it. And you had multiple violations as well in that file. 27 of 29 occurred while on probation. Multiple violations, you're still on parole for that case. 28 of 29 occurred while on parole back in 2022, still on parole for that one. And now we're here for this case. So you violate bond repetitively, you violate probation repetitively, you violate parole repetitively, you disappear when the probation office gives you opportunities for treatment. And again, you've got a long drug history. And I should see in here, if you've been in prison, I should have seen in here something about rehab in a prison. I don't see any of that on there. So, yeah. These aren't mistakes. These are choices. You're driving out there with all this stuff in your system for no reason. That's not acceptable. The court assesses $268 state minimum fees, $130 crime victim right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. We don't need DNA because it's clearly available in this kind of situation. The question is, are there any supervision fees? Well, the answer to that is no. Court sentences the defendant for, hold on. Are there any enhancements here?
No, Your Honor.
No. All right, thank you. As to both counts 1 and 2, the defendant is sentenced to 18 to 48 months. And because he's on bond or parole, he doesn't get any credit. I find that that sentence is reasonable, proportional for all the factors that I've discussed. I also could find that I don't even know if the guidelines scored the defendant adequately enough, considering the danger he put other people in. For instance, there should have been potentially other charges for operating while underneath the influence of controlled substances. That could have been charged down there. And you have 120 PRV points at the age of 32. I don't understand, but that's the sentence. Mr. Sapp, Mr. Martell is going to bring to you 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of the document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the pleas in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Have I missed anything, Ms. Simmons?
Yes, Your Honor. Just for clarification of the record.
Oh, they run consecutive to any sentence that he's still serving on parole.
Okay,
Or sorry, for any file for which he's on parole.
yes.
Yes.
What about? count
And
one
I'm sorry,
count two?
and between counts 1 and 2, they run concurrent to one another.
Thank you, Your Honor.
Thank you. Mr. Carnes, anything else?
No, thank you.
All right. Mr. Hertel will take my document. Thank you. All right. Mr. Sapp, when you get out, let's hope you that while you're on parole next time. Hope you can comply. We are adjourned.
Well, hopefully that guy gets his life together. It sounds like he's got a whole lot of problems, especially for his age. I'm worried about him that he's just going to go career on this thing, but time will tell, I suppose. We'll hope for the best for him that he gets his life sorted. Things are a little bit quiet out there at the moment. Again, I'm monitoring 6 different courtrooms, but let's ride with Judge Fleischer for a little bit until something pops off someplace else.
You just send word together.
What's up, man? Are you ready or no?
Yeah, Ms. Johnson, Commissioner Johnson.
You said Kamisha Johnson?
Yes, is that how you pronounce your name?
Yes, sir.
Yes, Judge,
You're
Kamisha Johnson.
appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already filed PC and did bond condition.
Yeah, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, then could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 152.
I went there, that's why I have asked you.
Don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular
Because
license?
on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning, otherwise you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do for first and foremost. Okay, great. Great. Good. All right. Good morning.
I'm here on Darren Cassidy. He's in custody. I'm just approaching on a bond reduction, Judge. As for discovery, on the new case, nothing is in. On the older case, the body cam is in. The state wants to reach out to the complaining witness on the newer case before they make an offer. So that's where we are discovery wise.
Okay, what do you want?
He's asking for PR bonds, Judge. Oh, I'm just doing my job.
I know. He doesn't show up though. He never, it's 4 times he's taken off on us.
Would you consider a bond in the amount of $500 on each?
State. Cassidy.
Yes, Your Honor.
She wants a $500 bond on each. What do you think?
Your Honor, I think the state's concern is just, we've got a new charge here. This one is allegedly.
What you say in the home?
It's a personal property. I think it was the yard, not bird we've had. But, Your Honor, I think the state is concerned that he's taken off a lot.
The first one we have is 1,010.
Mm-hmm.
You know, if you want, I'll do, 1,013 on both, so I know that it's, 1,003 on both. So I know, but I can't possibly give him a PR. He just doesn't show up.
Understood, Judge.
But do you want that?
Sure. Thank you. That's all I have to.
And I need you to do me a favor, please.
Yes, Judge.
Cassidy,
Mhm.
if he's in custody, if he bonds out, he needs a GPS prior to release.
Yes, Judge. Any other conditions?
That's it. Show up his warrant.
Yes, prior to release. Excluding the one for hearing?
No, just because he doesn't show up.
Yes, Judge. Don't say anything. I see. Hey Trey, I'm gonna do a GPS prior to on both of Cassidy's cases.
All right, get the card over there.
Because you never know, somebody else is fine. I don't know. Maybe we'll just see if the national identity is supposed to be this has come with this one. Okay, that's business. Yeah, well, is it a mistake?
A lot of dead air in a lot of the courts right now, but let's go over to 14B and Judge Washington. She's actually talking, which is more than most judges are doing at the moment.
I see counsel in the breakout room.
Yes, Your Honor.
Thank you.
And I say she's the only one talking and she makes a liar out of me. Let's go back to Judge Elmore, who we monitored earlier today as he did a sentencing. He's live right now, working with another customer.
Guilty of that offense. Turning your attention back to the date of February 15th, 2025 in the city of Cadillac here in Wexford County. What happened?
I possessed methamphetamine,
Where were you when you were found to be in possession of it?
by the Speedway area.
Okay, the Speedway over by Crippen and Shelby
Yeah.
Street. Okay, and where was it found? Was it in a car, on your person?
It was in my jacket pocket, right here on the side, on the inside, it fell out when they
All right.
were arresting me.
Okay, and was this, I always chuckle when I ask this, was it your jacket?
Yes,
Some people like to tell me they wear other people's jackets or pants or underwear. And it's in there. All right, and so you knew it was there
yes,
and you knew it was meth?
yes.
I'd like to ask this other question too, because it helps make sure to clarify a point. Was it in like a baggie or some container?
Both.
Both. So if you were to look through the baggie, you could actually see some white substance in there.
Yes.
Thank you. All right. I don't know why. I gotta come up with some other way besides pointing at my mouth. That sounds really stupid. Tugging on my ear may not work either. All right. Did you have any lawful reason to possess it?
No.
Mr. Carnes, I believe she's provided on a factual basis.
Yes, sir.
Mr. Burdette?
Yes, sir.
Mr. Carnes, you aware of any other promises, search or inducements?
No, Your Honor.
Mr. Burdette?
No, sir.
Mr. Carnes, you believe the court complies with court rule 6.302?
Yes, sir.
Mr. Burdette?
Yes, sir.
The court agrees and finds the defense plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense. Therefore, the defendant is found guilty of count one. The enhancements and count two will be dismissed at the time of sentencing. Sentencing will probably take place in about 4, potentially 5 weeks. We do them every Monday morning. Between now and then, an agent must prepare a pre-sentence investigation report. That report will describe the offense, the pretrial agreement, any statements, information you make or provide, information about your prior convictions and performance on bond and probation, as well as a score in the Michigan sentencing guidelines. And it will also make a recommendation. Please keep in mind that the recommendation and the guidelines are merely tools, as it is the court alone that determines what the punishment is. Do you understand?
Yes.
I said punishment. I meant to say sentence, because it's not always about punishment. I apologize. There are 3 steps that involve you. One of them is the packet that the clerk just handed to the bailiff. You can complete that packet, turn it in. Next, you'll be subject to an interview with an agent from the Department of Corrections. And also after that, oh wait, you have the right to have your attorney present for the interview. Then Mr. Burdett's going to get this report probably in about 2 to 3 weeks, and you're going to go over it with him. He needs to make sure he goes over with you because he needs to make sure all the information is correct. You understand? Any questions about what we have done today, Ms. Southwick?
No.
Mr. Carnes?
No, Your Honor.
Mr. Burdette?
No, Your Honor.
Is she on bond for anywhere else? Any other charges? Oh, she didn't have bond. She didn't have probation either. So, okay.
She's just on this case.
Copy. All right. Thank you very much. We're adjourned. We are next taking up the case of People of the State of Michigan versus Leonard Hoover. This is file 24-13953 F8. You may be seated. Please.
Joanna.
I'm Jeff Pearson. I'm here on behalf of Mr. Hoover.
Thank you. Mr. Hoover is here seated next to counsel. Now over here at the prosecutor's table is Ms. Lindsay Simpson, an agent from the Michigan Department of Corrections. We are here today for a sentencing in this case. There was a conviction for criminal sexual conduct in the 4th degree pursuant to a no contest plea.
Yeah.
Court has received the pre-sentence investigation report. I'm just going to make a quick look at it. There were a couple things that I needed to address today. First, I received through my staff an email from an individual named Katie Goines, Goines, and she wasn't, as I understand, that's the defendant's biological daughter. Is that correct?
Yes, Your Honor.
And she isn't the parent of the victim in the case.
No, Your Honor.
She's not the guardian of the victim in the case. Okay. Do we anticipate hearing a victim impact statement today?
Yeah.
The reason why I bring this up is I don't think I can consider the letter. I mean, she's not the victim.
Right.
And she's not the parent of the victim or the guardian of the victim. And she's not speaking on behalf of the victim. She's just sharing reference to other allegations for which there are no there's no convictions.
We also received a letter from his niece, his brother, and her daughter.
Yeah, so
that
hold
we
on.
didn't provide.
Yeah, so let me go. These went directly to my staff somehow. So my reason for making the statement is to say, once I saw that the email, I read in the first paragraph who the person was. I understand that she is the person who may have initiated the report, and they got law enforcement to go interview the victim, but I can't consider the information contained herein because it has nothing to do, I'm sorry, it's inappropriate because it's not a plea to it. I can only consider the evidence that was really a part of the police report. which is what I use for the no contest plea. And if there isn't a plea, because there's no charge to it, I can't consider it. So that's my long-winded way of saying, I appreciate the person sending the letter. Can't consider it. The next is an email that I know went to both my office and Miss Carey. This one is from Joanna Hoover. One moment. Is the paternal niece. Is she any relationship to the victim, Miss Carey?
Not that I know of, no.
All right. And by the way, it says parental niece in the first line, so I understand there might be some concerns, but the law does not allow me, in my interpretation, to consider the contents of that. Place that one off to the side, and I cannot add it to the pre-sentence investigation report. I also received an anonymous letter from a concerned citizen. That's what it just says, a concerned citizen. And there's nothing in there in the first paragraph that let me believe it came from the victim. I, by law, am not allowed to consider that either. So I have to place that one to the side. I appreciate that people have these concerns. And maybe some of that kind of communication would be relevant, say, at a trial. For instance, underneath MCL 768.27 B and C, where you can use prior acts to show propensity, to encourage the court or a jury to find the defendant guilty, but I can't use it for sentencing. It would be unlawful for me to do so. So again, I appreciate that there are concerned citizens and concerned family members, but by law, I am not allowed to consider it. Next, one moment. Raises a concern for me on CFJ 284, page 2, underneath the description of the offense, which largely comes from the Department of Corrections and its review of the police report. What are the initials again of the victim of the case? E-A, all right. And that just helps me, and that's, I won't state the name of the child at the time, but on CFJ 284, page 2, the information presented by Ms. Goins, I'm worried about the language that makes it sound like it's a finding of fact. I would fully anticipate if I didn't make this change, they could come back to the appeal if this were ever to follow the defendant. But I do believe the language that Katie says, I came forward because, but where it says because he's done X in the past, she could say because I believe he has done X. In other words, I don't want the document to state a finding that he has done X in the past to other people. Does that make sense, Ms. Simmons?
Yes, Your Honor. I was going based on the police report. I should have worded that differently.
Yeah, I want you to please word that differently because again, I can't sentence the defendant based upon what has happened in the past when that past is not contested by a fact finder or jury.
And we're looking at the first two paragraphs there.
Yeah, I remember it only being the first two paragraphs.
Okay.
Because the next after that It begins on July 30th, 2024, when the trooper began investigating the case. Those facts are fully relevant.
Okay.
So, Ms. Carey, any comment or objection to my approach?
No.
Mr. Harrison, I assume the defense doesn't either.
I concur with your analysis, Your Honor.
One moment. All right. Ms. Carey, how old is the victim now? Still a minor?
Feed out of Wexford County seems to have gotten buggy all of a sudden. Let's go over to Judge Boyd's court.
2024 CR 3163, State of Texas versus Enrique Soriano. Can I have parties announced for the record? For the state,
Andrew Harris, Sadelman.
defense,
George Sharman on behalf of Mr. Soriano.
and are you Mr. Soriano?
Yes, Judge.
All right, you entered a plea on January 13th, a guilty to the offense of driving while intoxicated, third or more. PSI and TAP evaluation were ordered. According to your plea bargain agreement, the state recommends community supervision. They're asking that your punishment be assessed at 4 years in the prison. Have both parties had a chance to review the PSI and TAP evaluation? State?
Yes, Judge.
Defense?
Yes.
Any objection? State?
No, Judge.
Defense?
No objections to it.
All right, anything you wish to say on behalf of your client?
Would you explain to you're applying for probation? Is that right?
Yes. Applying for probation.
And tell her about your family and what's happening with you.
So back in November, my wife,
Well, you want to raise your right hand?
yes,
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, I do.
All right, you can lower your hand, state your name for the record.
Enrique Soriano.
All right, what would you like to say?
So back in November, my wife lost her grandpa and she was having like breakdowns. So she got prescription medication, which is I think like eskeletochrome. So she was taking that for a couple weeks, and then she had like a screening for a hernia. So she had stopped taking them for the whole week. That caused her to get a mental illness. So she had to get hospitalized at the specialty transplant hospital for psychosis and bipolar 1. So that caused a whole bunch of stuff. She can't drive. I have to take care of her basically. And she relapsed back in January, still with the same thing, psychosis and all of that stuff. So I had to take 2 months off in order for me to take care of her. I just recently started working again in January, but I still got to take care of her. I got to take care of my 2 kids. I got to go to work. So I'm the only one in the household working now. So I'm the only one paying all the bills. I got 2 car notes, rent, my kids' food, things like that. So I'm picking my kids up from school. I'm the one taking them to school, picking them
Your
up.
problem is that they're asking for inpatient treatment. That's what we need to get to the point. So what you're giving me is reasons why you don't want to do inpatient treatment. But it's not addressing the underlying problem, which is they say you need inpatient drug treatment.
Judge, if I could,
Excuse me, we're on the record.
I would hope that you could give him intensive outpatient treatment and hold that other in abeyance, because I think he's going to do well with that, but he's got to help his family. He's got to be there for them.
State agrees with the recommendation of the supervision department.
All right, the recommendation says inpatient treatment, or they say I could consider intensive outpatient treatment. How many children do you have?
I have 2 year-old,
What are their ages?
8 and 6.
And what is your work schedule?
Tuesday through Saturday, 10 to 7.
That's 10 a.m.
Yes, ma'am.
to 7 p.m.
Yes, Judge.
All right, so who's looking after children during those times?
My wife is.
So I
Yeah.
mean, he trusts her to look after the children from 10 a.m. to 7 p.m.
Do you have any other help with you?
We do have a support system, yes.
Who's your support system?
So family members, family friends, you know, we recently moved, so my brother's down the street now. But it was very intensive as far as like getting her stabilized. So we have been seeing her psychiatrist, you know, on a monthly basis. So she's really stable. So she's able to watch the kids. She's not a danger to herself or anyone around her. It was just the relapse. She still can't drive and none of that.
And see, the problem is you've been on probation before for DWI. And there's a motion to revoke file. And you were continued. And then you were terminated unsatisfactorily. Is there anything else?
Judge, that's what we're asking for. It's an outpatient.
All right, this is what the court is going to do. The court is going to sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person. Excuse me, you all are blocking probation. There's going to be proof of employment within 30 days. No employment as a home health care provider or with minors. A 2-year license suspension. And state, you may be excused.
Thank you, Judge.
All right, see, we're already violating the rules. There is to be victim impact panel live, DWI education, regular random UAs, ignition interlock for half the term, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. There's to be a referral to felony drug court. That's to be in custody. If not accepted, then SATA. And what I can tell you is felony drug court will see you before the week is out. Probation, is there anything else? Okay. And I'm sorry, also DWI intervention. All right, is there anything else you need from the court in order to be successful?
No, Judge.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, so have a seat in the box. They'll take you into custody. Yes.
Let's hop over to Southfield, Michigan, and Judge Sheila Johnson.
You said that was the
No, the 23rd. We don't know what date the PSI interview. He has to go down and arrange with them that date. And the 23rd is that we gave you for sentencing that you couldn't make. Yeah, you couldn't make it. So the 30th is the sentencing. So, sir, if I change his mind, you have to contact the probation department immediately to set up a date to be interviewed. Let's see if he has any history of habeas. Got a lot of domestic violence history. Got one bench warrant for operating while intoxicated. Is that the one you were dealing with? 52-4 Troy?
Probation, been 6 sentences of probation for that.
And you got a warrant out at the 16th District Court,
Which one is that?
Livonia, for violation of probation on the domestic violence.
Mom said that she was calling and they said they were seeing if they were going to accept the plea for the because they said they were trying to get me time served.
Bench warrant under 36th District Court for assault and battery. And there was a warrant in this case. So it says that might have been the original warrant.
Yeah, I never even knew about this one. I was never contacted by the police or anything. I knew about this when I was picked up on the part. They were doing a wellness check.
Well, I'll tell you one thing. You can't be around this Shaniqua Evans, and the bond conditions are GPS heaven prior to release. So all of that is still in force. Pretrial services supervision, you have to check in with pretrial services. You're not to go near Miss Ewing. You're not to have any other assaultive contact with anyone. You're not to go to 29295 Pointer Woods Drive in Southfield or 16645 Washburn Street in Detroit. You're not to possess weapons or firearms, no alcohol or drugs of any kind, and the GPS tether.
Given the fact that Mr. Carroll thank you say, is there any way to seem to pay for that tether usually when they
Yes, he has to pay for it.
is there no way to put that cost forward?
He has to have a tether and he has to pay for the tether.
How much do you know?
I don't work there, so I don't know what they charge per day. I don't know what they charge as a deposit for the unit. I have no idea. Okay, sir. This is a domestic violence charge. Very serious. Second offense. And more than that, because you got a history of assaultive behavior. We got to figure out what is going on with you and try to get you to open your mind up to get some counseling so you can stop this nonsense. I can't have you out there with this lady and you go over there and then what? I need to know where you are. You got family members. If they care enough about you and they got the funds, maybe they will lend you the money to get your tether. But I can't let you go without a tether. Look at this. I'm gonna show you what I'm looking at. And if you were me looking at this for somebody, you'd be saying the same thing. I don't know what this home invasion was about. That was dismissed. There was a domestic violence third, it says, was dismissed in April 2024. Who knows? Person, same person. Shaniqua Ewing probably didn't come. Another domestic violence in 2022. Witness did not appear. Dismissed. Sought with intent to do great bodily harm, less than murder. 2021. Dismissed. Witness didn't come. September 2015, domestic violence dismissed. Witness didn't come. And that was also assault by strangulation and felonious assault. Witness didn't come. Domestic violence dismissed. March of 2014, complaining witness failed to appear. 2012. Oh, that's a drunk driving. Let's see. We'll skip down. We'll skip down. We'll skip there. Okay. And of course, you've got warrants in the 36, the 52-4, and another domestic violence one in the 16th. That doesn't look good. So you can understand why you need, I don't even need to change the bond. I will change the bond, but you're going to have a tether. since you've done 42 or 3 days. That's the only reason I'm doing this. And bigger than this, sir, is you gotta want to change. You gotta want it. You gotta learn how it's okay if you don't control everybody. If they don't do what you want them to do or what you say, that's okay. Because people got free will. And if they're not doing it to the extent that it affects how you feel in the relationship, just get out, go get you another girlfriend who will do the things you want them to do the way you want them to do. But beating on anybody, like if somebody beat your mama down, pushed your mama, you would like not like it. Okay? Well, it's the same situation. No woman or man for that matter deserves to be attacked in a relationship. So you might not be a bad person, but you got a bad temper and a problem that you need to work on. And if you work on it, I guarantee you, you'll be calmer, you'll be happier, and your relationships will go better. You got to learn how, if they say something to you you don't like, let it roll off your back. And if it's something very, very important, then you wait till you calm down. Come back later and talk about the problem. But at some point, no relationship is worth having if you got to do this. It's just not. And I don't know what her problem may be too. Maybe she's reliant upon this because somebody was doing this to her mama and she thought that's how you show love. I don't know. But some of this is her and she didn't come.
You never really got into like a big altercation. They always make it seem like that, and she doesn't come because it's never been anything like that. Like
It's enough to get you charged. Let me tell you something. Listen to me. Listen to me. Okay, well, fine. You got to learn how to call the police and let them stop her from driving rather than touch you. Okay? You just got to do that. Because it doesn't take much to assault and batter someone. Just putting someone in fear of a battery is an assault. You don't have to touch them. But if you do touch them against their will, it can be as simple as a push. That's an assault. You don't have to hurt them. You don't have to injure them. You have to have that intent. And if you intentionally grabbing somebody or something closely connected to them, like keys and things like that, that might be just enough. And if she's getting that drunk that you got to do that, and I don't know how many times, and anybody can have something happen once, maybe you should rethink if that's a relationship for you. And this time apart probably be good for you both. Because you can work on you and she can figure out what's going on with her. And if you all are meant to be together down the road, hopefully you come back together as a little bit better off and have learned something so it might work. But right now, this is like, you know, what they say, the definition of insanity is you keep going back and keep doing the same thing over and you expect a different result and you don't get a different result. You just get multiple different charges. Does that make sense? It can't be right. Something wrong about this situation. So you need to let it go, work on you, and if it's gonna happen, once you're done with all these cases, then it'll come back to you. And if it's not meant to be for you, then you're way better off and you're more ahead of the game because you're out of it. And I'm not saying y'all don't think y'all love each other, whatever that kind of love is, but that might not be the best kind of love there is. You see? So the bond in this case, $750 cash as surety. You want to say anything, Mr. Shacklin? Okay, so I'm going to change it. I'm gonna make it a $3,000 personal bond. with the same conditions, which includes the GPS tether. Okay, and if you get out, contact probation and set an appointment. And your lawyer can give you the number to probation here. What is it, sir?
How do I know how much money I have to get together to get the check? How will I find that out?
I don't know.
My release date is on April 6th, so on April 6th, when they're ready to release me.
Okay. You could call right now pretrial services, since you're under pretrial services supervision. Pretrial services will be able to tell you who the tether company would be. And then you could call the tether company. And let me see if I know who his pretrial services person is. There might not have been anybody here. Oh, okay, good. So we'll see him back on April 30th. 9:30.
Thank you very much, Robin.
All right, thank you.
Let's go back over to Judge Boyd's court where she's about to do another sentencing.
24 CR 6359, State versus Kelly Cotner. Could I have parties announce for the record for the state?
Harris Salem.
Defense?
George Sharman on behalf of the defendant.
And are you Kelly Cotner?
Yes, ma'am.
All right, you entered a plea of guilty on January 13th. A PSI and a TAP evaluation was ordered. According to your plea bargain agreement, punishment is to be assessed at 8 years in the prison, and the state is recommending community supervision. Have both parties had a chance to review the PSI and the TAP evaluation?
I have, Your Honor. Yes, Judge.
And also, there was a DDRF mixed screening. Did both parties review that as well?
Yes, Judge. Which is that now?
The DDRF and MIC screening?
I don't know that I called the name of that.
It's a mental health evaluation.
Oh, yes, I looked at that.
All right, any objections?
No, Judge. No, Judge.
All right, anything you wish to say on behalf of your client?
Judge, we're asking for probation for you to follow the plea bargain. Ms. Cotner has been monitored the whole time. She had no violations, and she's had this device keep her in the home. She hasn't been driving. I think she's done everything positive that she could do to show this court that she would be a good probationer.
All right, state, you may be excused.
Thank you, Judge.
All right, this is what the court is going to do. The court is going to follow your agreement. The court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be a referral to felony drug court probation. She's already been accepted to felony drug court. They were just waiting for the outcome of her application. DWI intervention, DWI education course, VIP live, ignition interlock for half the term. There's to be 200 hours of community service restitution. Do you have any hobbies? What do you do?
Well, I like to read and go to AA meetings
Okay.
and visit with family and friends.
All right. So are you employed?
No, ma'am, I am retired, but due to expenses, I may have to seek part-time employment.
Okay. And who do you live with?
I live with a very nice elderly gentleman. He's a veteran. His name is Mr. Eloy Lopez Senior.
Mhm.
I rent a room in his home.
Okay. All right, so there's gonna be 200 hours community service restitution. How often are you doing AANA meetings?
Usually I try daily, but I would average 3 to 5 times a week minimum online because I've been under and am currently on 24/7 house arrest.
All right,
on
so
GPS.
there's gonna be sober support meetings 3 times per week. There's to be restitution of $60 for laboratory tests. That is to be to the Texas Department of Public Safety. Field visits 1 time per month until further notice. And I'm not going to order proof of employment because she's retired. But if she obtains employment, there's to be no employment. Sorry, excuse me. As a home health care provider or with minors. And if for some reason, if felony drug court is at capacity, then it'd be intensive outpatient treatment with probation. Probation, is there anything else? All right, is there anything else you need from the court?
Judge, she has a monitor.
State, do you have any objection to removal of the GPS monitor?
Okay.
All right, and GPS will be removed.
Do I need to get an order for that, or is that?
Just talk to the clerk.
Okay.
All right, is there anything else you need from the court to be successful?
No, ma'am, I would just like to say, Your Honor, that I'm very, very sorry. Words can't effectively convey the remorse I feel for ever having endangered a life. The safety of the community is the most important thing for anyone. I'd like to continue the life I've been leading since this incident happened, and that is a good Christian life. Practicing, putting God first and practicing my AA program daily, no days off. It's 24 hours a day, 7 days a week. And I'd like to continue that. I'd like to continue the help that I'm able to give others in recovery. And if I can help just one person not to drink and drive, then I'll feel very good. And I'd also like to thank you, Your Honor, your prosecutors, and your entire court staff for such grace and professionalism. I truly thank y'all. And this is truly a gift. And I thank you so much. And I thank God. Thank you.
Oh, thank you so much. You've made my day. I appreciate that.
Thank you.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? Did you understand and sign it?
Oh, do I need to sign?
Did you understand it and sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and probation, with regards to our community service, if you end up doing more in your AA meetings, by that I mean sometimes people become group leaders, sometimes they go to the meetings in person and they help set up, or they become a counselor. Let me know, and I'll consider waiving some of your community service hours. All right, thank you. And thank you. You're always on time. You're always dressed appropriately. I appreciate that.
Thank you, Judge Boyd.
Thank you. Have a good day.
You too.
And just wait in probation to go over conditions with you, and state you're excused.
Thank you, Judge.
All of the other courts that we're monitoring, 6 in total, are all falling silent at the moment. So we're going to go ahead and ride with Judge Boyd. everybody's either in recess or they've got nothing going on, or in the case of Judge Fleischer, I think he went in back to play Fortnite. So we'll stick with Judge Boyd for a while.
Probation with Cochner, that's supposed to be a 2-year license suspension as well. Thank you. Just 1 second. Ms. Cochner? All right, that's going to be a license suspension as well. All right, thank you. All right, just 1 second. I have to put this in the system.
Working on Dwayne Daniels on your docket today, but I've got to go on my mental health docket. And so I'm going to be out for probably about an hour and a half,
Okay.
and then I'll be back. Well, for Deputy Snow, he's in the back, but Deputy Snow not to take it back. Good.
Sure. Who's here on Ashley Caballero?
That's fine.
Where's she?
She's right here, yeah.
Y'all ready to proceed on the motion to revoke?
Yes, ma'am.
All right. Could I have a file stamp for a motion to revoke? And counsel, I need a trial court certification of defendants'
I'm
right.
gonna withdraw the motion, Your Honor.
All right. State, what's the reason for withdrawal of this motion?
Your Honor, this is Ms. Caballero's first motion to withdraw. In addition, not motion to withdraw, motion to enter adjudication of guilt. In addition, she has shown partial compliance with the conditions of supervision. She has completed.
All right, but she's been missing, according to your motion to revoke, since June.
Yes, she has, Judge.
So that's June, July, August, well, May, June, July, August, September, October, November. And you all want to withdraw?
Yes, Judge.
Your Honor, she hasn't reported because of irresponsibility. But she has shown a lot of responsibility in other ways. She's done the TAPI assessment, she's done the parenting classes, the inpatient program, she's completed it at Casa Mia. She's completed her.
If you're drug tested today, what are the results going to be?
Okay.
All right, so this is what we're going to do. I want her drug tested today.
Yes, ma'am.
And we're going to see what the results are.
Yes, ma'am.
All right. And why is she in custody? Because of the motion to revoke?
There's a warrant, Your Honor. That's fine.
All right, just have a seat. We're going to get you tested today.
And I brought her in to take care of it.
All right, thank you.
Yes, ma'am.
All right, who's here on Melbourne Zuniga? All right, is this a plea?
Yes.
All right, court is calling 2025 CR 000434 State versus Melbourne. Adelio Mejia Zuniga. Could I have parties announced?
Megan Galloway for the state, Macy Edwards for defense.
And are you Mr. Zuniga? All
Yes.
right, we have an interpreter here. Could you raise your right hand? Do you solemnly swear you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Your Honor, the interpreter's name is Jorge Valle.
Right. And counsel, do you speak Spanish?
I do not.
All right. All of these documents are in English. Were these documents explained to your client in Spanish?
Yes, ma'am.
And Mr. Zuniga, were all of these documents explained to you in Spanish?
Yes.
And did you understand?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
The court will find that the state is in compliance with discovery. Are there any applications in this case?
Yes, Judge.
All right, I'm trying to locate the application. To the clerk, do you have the application for,
It's a separate application.
yes,
Where do we pull?
there,
Okay,
over there.
then we need to do that. I'm sorry.
All right, sure.
I
You'll have a
apologize.
seat and then go over that document with your client. I'll call you right back up.
My apologies.
All right, Jonathan Dreamer.
We have a little talk in the hallway, Judge. I don't think this is an appropriate subject.
Where's the prosecutor?
No, no. Hey, have a seat. I'll call you in a second. No, it's, and-
Okay, well, they talk some things over. Let's hop over to Judge Shackelford's court.
Address the court prior to sentencing.
Okay, did you understand all of that, Mr. Ollie?
Yeah.
All right, so first, we will adjourn the pretrial just for discovery.
Yes, Your Honor, we're still trying to review the discovery. Have a problem with it.
Okay, and then we have an allegation, sir. The allegation is that you violated your bond. And the allegation is that you tested positive for alcohol on February 25th of 2025, and that was confirmed by a lab on March 16th of 2025. Do you understand that allegation?
Yes, ma'am. Yes, sir.
All right, and did you go over your probation violation or a bond violation advice or rights form with your attorney?
Yes.
Did you understand your rights?
Yes.
And did you sign the back of that, sir?
Yes, I did.
Sir, you understand that if you enter a plea guilty to this violation, you'd be waiving the hearing rights on this form. That we're not going to have a hearing if you say you're guilty. You understand that?
Okay, I found this on the web for you understand.
I must have said something that sounded like Siri. Sorry. You understand all of that?
Yes, Your Honor.
All right, and you understand that if you enter a plea of guilty or you're found guilty, I could amend your bond, I could revoke your bond, and put you in the Wayne County Jail, or I could continue your bond as it currently is. Do you understand all of that?
Yes, Your Honor.
All right, knowing all of that, to the allegation, you tested positive for alcohol on 3/25 or 2/25 of 25, and it was confirmed by a lab on March 16th. How do you plead?
Guilty.
Did you have something to drink? What is it you want to tell me?
Could tell you, but you wouldn't believe it.
Why? Because I've heard it all a million times. Let me guess.
Yeah.
Let me guess. You were at a cousin's house and there was punch and you didn't know there was alcohol in
I
it.
was at home.
Or maybe you ate something and maybe that thing had alcohol in it. Or maybe you dropped, I don't even know. Tell me, I'm dying. Don't keep me in suspense. What's your excuse?
It's really not an excuse. It's actually true. I did have company. It was at my house.
Mhm.
Came in. I have a juice that I make up because I'm a diabetic. I went in the house. I grabbed me a glass of juice. I brought my jug out with me. My company, they was there. They were doing it. They was drinking their drink. I got up. I went to the bathroom. I came back up. I sat back down. I started finished drinking my drink that I was drinking.
And you didn't feel that you were drinking? You
was
had no
nothing-
idea at any time that you were drinking alcohol?
No, because what I mix in my drink is raw beets.
Didn't you feel any effects of alcohol?
Huh?
Didn't you feel like, okay, maybe you didn't taste it, but at no point you were like, oh, I'm feeling a little
No,
toasty?
It wasn't no taste. It wasn't nothing. If you do like this, if I had some of it with me right now, and I just poured the glass, and let you do like this, just hold it to your nose. You don't gotta hold it up to your nose. You
All
can
right.
smell it from right here.
Here's the thing, Mr. Ali,
But everything else, I've been doing. I have.
here's the thing. The ETG levels were so high, like this test, the test results, it wasn't like you had a little sip and you might not have felt it. Like your test results are indicative to me as someone who got lit. So there's no way you're drinking beet juice all night.
No, it wasn't.
And I'm talking, listen, I'm tired of it. I'm tired of it. I'm just exhausted. There's no way you were at home drinking your beet juice. And at some point you're clearly getting drunk and you know beet juice doesn't get you drunk. And at some point you would have thought like, something's funny here because I feel intoxicated. And the level on your ETG is indicative to me of intoxication.
Okay.
Like very intoxicated. It's not like, I don't know what your tolerance for alcohol is, but this is a very high result. This isn't like you had a beer and tried to get away with something. This is like you partied all night. I mean, that's what that test result says to me. And you just had a violation.
The violation was on the 3rd, Your Honor. It was after the occurrence of this incident.
So he had this one out in the lab and then he picked up another one.
So when he had his previous bond violation hearing on the 3rd, this had just been sent out to the lab for confirmation. This current sample that we're here for.
That would have occurred.
So this is the one he wasn't drinking and the one after it was when he ate some gumbo?
Yeah.
The one that was held before was for the gumbo that occurred before this.
You are responsible for what you put in your body, sir. This is a second offense from driving and you had a BAC of over 0.17. These are the allegations that you're facing, okay? And all I'm telling you, you're not allowed to do, I mean, it's not like I put you on rigorous bond conditions. I said you can't drink while you're on bond.
Yes, Your Honor.
And twice now, and I have heard everything. I don't believe a word you're telling me, with all due respect, sir. So listen. Matt, has he been assessed for treatment court yet?
He has not been assessed for treatment court. To my knowledge, does not enter a play.
Can I see the two of you in back real quick? Just stay there, sir.
All right, we'll hang here for just a second and see if she comes back real quick. If not, we'll probably switch to another courtroom. Everybody's real quiet though this morning, to be honest with you. And Judge Fleischer's been gone for a good half hour now, so I definitely think he's playing Fortnite. Anyways, let's hang here for a second and see if they come back. So it seems like they're going to be a bit. Let's go back to Judge Boyd. She's got somebody else in front of her.
0000434. Could parties re-announce for the record, please?
Andrew Harris,
Lacey Edwards for defense.
All right. And are you Mr. Zuniga?
Yes.
Just give me 1 second, everyone. See, it's doing its crazy thing again. Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you?
Judge Shackelford's back, so let's finish that up and then we'll cut back to Boyd again. Never mind, whatever they did with that defendant, they've already dismissed him, so, and she had her volume cut off, so I got no idea what was going on there. But I did pause the feed from Judge Boyd so we can pick up where we left off there.
That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes. Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Zuniga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you confer with your client or speak with an attorney regarding his immigration status and the impact this plea will have on that status?
Yes.
All right, and did he have ample opportunity to meet with an attorney or meet with you about the impact this plea will have on his immigration status?
Yes.
Mr. Zuniga, did you understand by entering into this agreement, you will be deported?
Yes.
Did you understand you may be denied re-entry into the United States and naturalization?
Yes.
Knowing that, do you still wish to continue with this plea?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. State recommends community supervision. $60 to Texas DPS, restitution for testing, ignition interlock for half the term. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 10 days in the Bear County Jail as a condition. TAP evaluation. DWI intervention and victim impact live. Do you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, and Ms. Cotner, are you still here? All right, please don't leave the courtroom, okay? All right, state, any evidence to support the defendant's plea?
Should be contained in exhibit 1 and attachments, Judge.
No objection.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Your Honor, we just respectfully request the court follows the agreement and the recommendation of the state. This is my client's first felony offense. It's the first DWI he's had since 2008. I think he's learned his lesson. He's been in custody since his arrest.
All right, the court will sentence you to a $2,000 fine. That will be probated, 6 years in the prison, suspended and probated for 6 years. Regular reporting by Zoom or in person, $60 restitution to Texas DPS for drug testing, ignition interlock for half the term, 10 days in the Bear County Jail as a condition of probation, proof of employment within 30 days, no employment as a home health care provider or with minors, 2 years license suspension, DWI intervention, DWI education, victim impact live, no re-entry into the United States. Probation, is there anything else? I'm sorry? Regular UAs. All right, is there anything else you need from the court to be successful?
No,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
yes,
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes.
All right, good luck to you. Thank you.
Thank you.
Thank you.
Okie dokie, I think we're going to go ahead and leave it there for today, for today's live stream. One thing I do want to point out, we do this trial format where we do an entire trial and we condense it down into under an hour. We dropped one of those over the weekend. You can find it on the channel. It's really unique because this particular one was a DUI case, which we talked about in the chat here this morning, how it's so common, these DUIs. But this defendant actually chose to represent himself, and it was a really interesting watch. So be sure to check that out. You can find that on our channel. If we did a good job today and you enjoyed the live stream, please put a thumbs up on it. That lets the algorithm know that people enjoy it. Appreciate you tuning in today. Thanks so much. We'll see you tomorrow, 10 a.m. Eastern, 7 p.m. Pacific. God bless.